Welcome to Law Potato, Hot Legal Topics with Idaho Values.
Welcome back to Law Potato, Hot Legal Topics with Idaho Values with Alan Harrison and Laura Wallis of Alan R. Harrison Law. Alan is an Idaho estate planning attorney, and Laura is the firm's chief operating officer, bringing a systems-focused and family-centered perspective to the work that they do. I'm Leanne Lyon, and today we are talking about guardianships in Idaho. We'll go over when they're needed, how the process works, and why planning ahead can make the meaningful difference for families. Well, to start today, can you explain what a guardianship is under Idaho law and the kinds of situations where it becomes necessary?
Yes, I'll give the legal answer, and Laura's got the practical experience that she'll be able to give. But first of all, if a parent is going to be gone for an extended time, they can always do a temporary guardianship. It's just a form they fill out. It's a state standard form. They can do it up to 6 months for a non-family member and up to 3 years for a family member. And so that's one type of a guardianship. It's not through the court system or anything like that. The family can just sign it and appoint that guardian. Through the court system, there's several different kinds of guardianships. There's a minor guardianship, there's a development delayed guardianship, and there's an incapacitated guardianship. So minor guardianships is typically a grandparent. It has a child who is not able to provide the care that they need for the grandchildren. And so the grandparent steps up and obtains guardianship for their grandchildren and take care of them until the parents can take care of it. And there's state standard forms that they can use to do that online. And that's typically where we see a lot of families go to deal with that. The second one is development disability. And so this is someone who has a developmental disability, autism, Down syndrome, and various other development disabilities. And there's a process that they file a petition with the court, and go through in order to be able to get guardianship of their child. And then the last one's incapacitated. And this is typically for those that are elderly or those that have mental health issues. An elderly person gets dementia or Alzheimer's, or someone's hurt and they're in the hospital and they're not able to communicate and they don't have an estate plan, where they don't have powers of attorney, or there's just issues amongst the family as to who should be making the decisions. Then that's when we can file for that incapacitated guardianship. And with development delayed, minor, and with incapacitated, all of them you can file for a temporary guardianship or an emergency guardianship, in which that gives someone immediate authority to be able to make decisions for them.
And so the practical side of all of that is when you have, especially if you're a parent and you have a kiddo who's turning 18, guardianship is that magic thing. I don't know if it's magic, but it's that thing that allows you to still be in the room with a voice on helping your loved one. So I know in our family, turning 18 is not a magic switch that makes your kid able to adult. And especially when they have a developmental disability that would preclude them from making choices that will keep them safe. 18 is this magic day that as a parent, you don't get a voice, but they aren't ready necessarily to be able to make decisions that they need to stay safe. So for us, it was a decision that we needed to make so that we could make sure that our kiddo had the support they needed to stay safe and make good decisions and be able to continue progressing with the support that they needed. That isn't, and I guess it's important to me that we say that not every person who has a disability needs a guardian, and very far from it. It's not really the case, but it comes down to that. Can they stay safe with the decisions that they are making? Are they able to understand and make those choices? If the answer is no, then a conversation about guardianship is important.
Well, it seems like guardianships sometimes come up during already stressful moments. What tends to prompt families to start looking into guardianship, and what is usually happening in their lives at that point?
Well, if you're a parent of a kid turning 18, you've got a very specific date circled on the calendar for which you might not be invited to help make decisions anymore. So in that situation, you know it's coming and it's very obvious that it's about to happen, and you have some decisions, but you also have some lead time. And guardianship is not a quick process. So for us as parents going into an adulthood situation, we have some warning and we can approach it a little calmer. But for those who end up in situations with potentially dementia or mental health issues or an accident or injury that precludes them from being able to make decisions, that is just a little bit more stressful. And it's a little bit more, I don't know, a little more intense because, as I said, guardianship is not a quick process. And so that's when things like emergency guardianship come in place that Alan just mentioned. It's the same process, but it's kind of in two steps to get you the authority you need to step in and act while you're getting everything taken care of in the court. I'll let Alan answer any more of that he thinks I may have missed.
Yeah, no, and with the minor guardianship, the only thing I would add on there is it's just a grandparent dealing with a grandchild that whose parents are unable to take care of them. And so, yeah, that is a very stressful time. They're trying to figure out what to do, how to help the grandchild, how to help their children move forward. But with the development delayed, with a parent that has a special needs child that they're turning 18, we like to visit with them when they're about 17 to talk about the options and see if doing powers of attorney is what's best or whether guardianship would be more appropriate. And then with the incapacitated one, Laura was right that if someone has Alzheimer's or dementia, you kind of do start to see where things are going. And if they have their estate plan and they have powers of attorney in place and they have family members who are all getting along and honoring those, and they have doctors and counselors and everyone is willing to honor those powers of attorney, that is why we do estate planning, is to avoid guardianship in those cases. But when you don't have those documents in place, or you don't have family getting along, or you have providers that aren't willing to recognize them for whatever reason, then that's when I like to push back on the providers and say, here, we have written documents, and this is what they have said that they want. We need you to honor those. Help us understand why you're not honoring them. Usually it's when family's not quite getting along. That's when, if someone has documents, if the family's not getting along, that's when we usually will see people come and get guardianship.
And I think it's important. Alan said that, it's very often grandparents getting guardianship of their grandchildren. I don't want anyone to think that that's the only reason that you would have a minor guardianship. Sometimes we have aunts or uncles or older cousins that would step in as well. It's most of the time grandparents, but not all of the time. And it's not a requirement that they be grandparents for minor guardians. And I also think that it's important for people to know that in Idaho, powers of attorney can be revoked verbally. And that means if someone says, I don't want them helping me anymore, then it can stop, which is one of the reasons that we talk about guardianship with individuals who have highs and lows, good days, bad days, that may, be very willing to work with their agents to help them on some days and other days not. And so guardianship becomes a bigger question when the person changes their mind a whole bunch, but they do not understand the ramifications of their decisions. They do not understand why those decisions may or may not be safe. So that's an important consideration when we're talking about, is guardianship appropriate for those people who cycle between, being, feeling one way and feeling another, and it could put them in danger easily.
I think both of you have mentioned that it doesn't happen overnight, that guardianship takes some time. So how does the guardianship process generally unfold in Idaho? And what should families expect emotionally and practically as they move through it?
Yeah, as far as the process goes, we meet with, as I mentioned earlier, we like to meet with families when their child's about 17. If they want to meet before that, that's fine. But definitely by the time they're 17, so we can help understand so we want to meet with families when the child's about 17, so we can just go through the process and help understand what the disability of their child is. The process is that We fill out a petition that we file with the court. There's some a proposed guardian care plan that they file. They have to get a criminal background check. They also need to meet with the evaluation committee, and the evaluation committee won't meet with them until they have done an adult psychological evaluation, or we have the eligibility report that has the proper testing that they need. And so we just tell families, bring what you have as far as testing goes, and we'll work with the state to see if that's sufficient or if they do need to get further testing. If they come in when they're 17 and they need to get that adult psychological evaluation, then there's time to schedule that. Those can be out 5-6 months before you schedule them, and then to get the results back. And so that's why we are encouraging families to come in earlier so that we can get that testing done. Once they have that testing and we've got all the documentations, they meet with the evaluation committee, who will write a report to the court as to whether their child is disabled and then who the appropriate guardian would be. And once we get that report, we file that with the court, set up a hearing, and then there's an attorney that meets with the family and with the special needs child. And he or she does a report to the court as to whether they feel that this is appropriate. And then we have a court hearing. Depending on the judge and depending on the county, will determine whether that hearing is in person or whether it's held by Zoom. Currently, we just had a judge change here in our county, and they're now being held by Zoom. Prior to that, they had all been held in person. And so it just really depends on the county and the judge, their personal preference as to whether it's in person or not. After that hearing, the judge will issue orders. We get them by email, and we just forward those to the client. And the letters of guardianship or the letters of guardian and conservatorship, that's the document that the family will need in order to be able to make decisions and talk to providers for the child. And so that's the process. It usually takes about, if everyone's got the testing done, it's about a 4-month process. If 4 to 5 months process, if there is not testing done and that needs to be done, then that time frame can be extended in order to get that proper testing back.
So Alan said a couple of things that I wanted to kind of address. One is he mentioned guardianship and conservatorship. So some states make guardianship handle both the person and the finances, but Idaho breaks them up. So a guardian is able to make decisions for the person specifically, their living arrangements and their medical care and things to do specifically with the person. But a conservator is responsible for the finances. Now, not everyone needs a conservator. If the person with disabilities, if their only income is Social Security, then it may be that the rep payee would be able to handle that if that is their only source of income. But if it isn't, or if there are more complications with the finances than that, or they have resources from other places, then having a conservator is important. When it comes to timelines for parents, some of the things that are important that are going to happen at 18 need to kind of be considered while working on guardianship, because some of those things can overlap. So for example, when we're talking about the testing is going to be needed for guardianship to show the level of functioning of this individual. And we specifically were talking about developmental disabilities. There are some other steps that are slightly different for incapacity for those that are older. But when talking about developmental disabilities, the likelihood that this individual will be applying for benefits through Social Security when they turn 18 is also pretty high. And Social Security likes their testing to be very current. So we try not to have testing that is older than about 17 and a half for that individual. So if you have testing that's 16, it's great, but it may, Social Security may ask you to come back and do it again. So if you can get testing done in that window, then you're able to go ahead and hopefully, not always, and it's not a guarantee, but use that for both situations at the same time, which is kind of a win. And Alan pointed out that it takes a long time to get that testing scheduled. He said 5 to 6 months. Sometimes it could be 6 to 8 months too. It just really depends on where you live and how backlogged your provider is, your insurance, a bunch of other things. So it's good to know when you need to get the testing and what testing you need to have done. And then I think it's also important to know that when you're having an evaluation committee, you're going into a meeting with a group of people that chances are you do not know. and they're going to meet you, and they're going to meet your almost adult kiddo. And they're going to have conversations about, what would they do in certain circumstances. And they're just going to get to know you and just kind of ask questions and see what those responses look like. Now, we've talked about what happens if they are turning 18, but sometimes we have those who are already 18 and they need a guardian because it just isn't working safely for them to be their own guardian after 18. And when we refer to it as be their own guardian, they're adulting without a guardian. And so we do handle guardianships after 18, but we just kind of talk about it as that 18 because the majority of them have parents who are coming before then, but not always. With incapacity, things are a little bit different. They don't have an evaluation committee. They, Alan, I believe we call it a court visitor, right? And so they may not need the same level of testing or the same types of results. It depends on the situation. Someone who has been in an accident and is in a coma is not going to go out and get a psych test. So it's just a little bit different for those tests, but most of it is very similar. And the hearings and stuff like that can be very similar. It just may be more involved depending on the circumstances behind that incapacity.
Well, as we're wrapping up here, it's sometimes helpful to share stories. Can you share a story that highlights how thoughtful guardianship planning helped a family navigate a difficult situation with more clarity or stability? Or maybe each of you have a story to share.
Well, I will say this. A lot of parents ask us, they come to us with ideas of what guardianship is and what it is not. And so I think it's important for them to know some things it is not. Becoming a guardian doesn't make you legally responsible for their actions. So if your kid commits a crime, you're not being sued for it. And you don't have to provide for them with your own funds. So sometimes we have guardians who aren't parents and they wonder and worry about that. So that I think is important to know. Guardians are supposed to give the individual the opportunity to make as many choices on their own as they can. So my kiddo makes most of their choices on their own. We step in as guardians when that decision may not be safe and they're not understanding the harm that could come to them. But we allow them to talk it through, give us their whys, kind of discuss it with them, and hope that they can kind of talk it through and get to a spot that they understand what is safe and what is going to hit their goals best. And we, as I said, we only step in if there's a safety issue that is going to cause harm that they really just don't understand what they're doing. And that has really given them a lot of autonomy and the desire to keep progressing and moving because, and achieving because they know they can and they're building confidence. And that's what the intent of guardianship is. I think that sometimes people see things in the media that are sensationalized and they go, oh no, this is horrible. Done well, guardianship is really about supporting the person while they continue to grow and get better.
Yeah, and I'll just share two quick examples. One from a development disabled individual. They were not living in the home. They were in a home with several other individuals. And one of the other individuals was bringing people into their room. And the home felt like they didn't want to violate that individual's rights and wanted to make sure they could bring whoever they wanted into their room. Well, it created not a good situation for the other residents of the home. And so the guardian, because they were guardian, was able to speak for their child and to say, hey, this is making my child feel uncomfortable. This is not a good situation for them. You can't allow this. This is what we have to allow them their rights. And if there would not have been a guardianship, the home could have asked the special needs child if they're okay with it. And they said, yes, yeah, I'm okay with it, because they didn't have the capacity to advocate for themselves. But because the mom was the guardian, she was able to step in and just say, this is not right. And eventually, because the home did not correct it, she was able to remove her daughter. And I was told in the meeting, the daughter was crying and just was clearly needed to be moved. But it was only because they had the guardianship that they were able to do that. So that's an interesting. That was a good incident with a development delayed. The other one with an incapacitated, we had a mother that was being taken advantage of by someone overseas, or well, actually, we don't know where they were from. They were just saying, "Sell your home, send me the money, I'll buy you a new house, and then I'll use some of that money to buy a plane ticket, and then I'll come pick you. I'll come pick you up, and we'll come to our new house." And so they'd actually had a loan given to them by some people, giving them an advance on it. And luckily, the son was able to keep pressing the mom about what was going on. And eventually, she said, "Hey, this is what's going on, and we have to be out of here by Monday." And we were able to file an emergency guardianship and be able to then work with the realtor and call the sale off and save the home. And mother did not like that, and hated her son, and which is very unfortunate due to where she was mentally and physically. But in that situation, we were able to help protect his mom and provide her the care that she needed.
Important work. Well, that wraps up today's episode of Law Potato, hot legal topics with Idaho values. If you want to learn more about guardianships, estate planning, or how to plan ahead for changing family needs in Idaho, you can find Alan Harrison and Laura Wallis at aharrisonlaw.com. Thanks for listening, and remember to like, leave a review, and subscribe to the show so you don't miss the next episode. Thank you, Alan and Laura.
Good to be here.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.